cease to maintain case law. So this is case law relating to when a local authority makes a decision that they're no longer going to maintain a plan and it's going to cease, basically. So AB versus East Sussex County Council 2024. The Same Tribunal's decision to uphold the local authority's decision to cease to maintain the EHE plan was unlawful. The upper tribunal confirmed that the starting point is to identify and consider the special educational provision required before assessing whether it is no longer needed or determining the appropriate placement. The LA or the Same Tribunal standing in its place must consider whether the child or young person would meet the criteria for an EHCP plan in the first instance. If the answer is yes, making it necessary under Section 37(1) of the Children and Families Act 2014, it would be difficult to justify ceasing to maintain the plan. Consideration of whether outcomes have been achieved must not be treated as a simple tick box exercise. There must be a proper evaluation of whether the education or training outcomes in the plan have been met. The LA Tribunal must take a broad view of education and training, not just focus on an academic attainment, in line with Section 2 and Section 15ZA of the Education Act 1996 and Section 21 of the Children and Families Act 2014. And where SEM Regulation 30 applies, for example, where a young person aged 18 or over is not attending a placement or receiving educational training and their wishes have not been obtained, the SEND Tribunal should take active steps to seek and consider their views during an appeal. So basically this is setting out what the local authority and the tribunal should have done to determine whether the plan can be ceased, whether the person still needs an EHCP, whether they've still got special educational provision, whether they have met the outcomes within the plan, and what that young person's choice of next steps is going to be, and their views on their appeal. And what they're saying is that they failed to do this, therefore they didn't have grounds to actually cease to maintain the plan. So BM versus Cheshire East Council 2018. A local authority argued that it could cease to maintain an EHC plan because the young person had achieved the outcomes set out within it. The upper tribunal held that this alone was not sufficient to justify ceasing the plan. It emphasised that local authorities must ensure they have up-to-date and adequate information about a young person before making such a decision. The tribunal also provided their guidance on Regulation 31 of the SEM Regulations 2014, which outlines circumstances in which local authority may not cease to maintain an EHCP plan for a person aged 18 or over. So basically what they're saying here, before they make decisions, they also need to ensure that all the advice and information that they've got is up to date about the young person, and that they have not made that decision on outdated information that's not accurate or reliable. EM versus Royal Borough of Windsor and Maidenhead 2024. The local authority decided to cease to maintain a young person's EHC plan on the basis that he would be better supported in adult care setting, had received intensive provision with only limited progress, and was unlikely to make significant progress in future. The upper tribunal confirmed that when determining whether an EHC plan remains necessary, the law does not require a young person to achieve a particular level of progress or attain specific outcomes. A decision to cease a plan cannot be based on whether the progress made is proportionate to the level of provision received. While the young person's potential for future learning may be a relevant consideration, there is no requirement for it to reach a particular threshold. A defined level of potential is not necessary for an EHC plan to remain necessary. The case also reiterates the requirement for the SEND Tribunal to provide clear and adequate reasons for its decision. So basically what they're saying here is you've got to be careful what decisions you're making and how you're making these decisions. You can't just make your own criteria up to, for these decisions. It's not down to the local authority to say that we're not supporting you anymore, you haven't got to the level that we expected you to get at, because that's not a criteria of whether they're going to maintain a plan or not. It's about what is still relevant and what is still, if it is the best decision for the child or young person going forward. So basically, they've got to be clear and the reasons have got to be sufficient enough. Hampshire County Council versus 1CGC and 2GC Sen 2024. So in this case, the upper tribunal held that a decision to cease to maintain an EHC plan will be invalid if it is made in breach of the procedural requirements set out in Regulation 31 of the SEN Regulations 2014, where this results in disadvantage to the parent or young person. Considered what it means for a child or young person to be in a local authority area for the purpose of responsibility under the Children's and Families Act 2014, confirming that while physical presence may be relevant, the key question is whether the child or young person is ordinarily or habitually resident there, even if temporarily absent, as in this case, due to a parent's overseas deployment, and confirm that local authorities retain a discretion under Section 45 of the Children's and Families Act 2014 to continue maintaining a plan even when they are no longer responsible for the child or young person. In this case, that discretion did not apply because the child remained within the local authority's area. Where a child or young person is temporarily overseas but the local authority remains responsible, it may simply maintain existing arrangements until the family returns to the UK. So this is on about when a child is family is in the forces and they are deployed overseas because of a parent's deployment. That child still remains the responsibility of the locality that they originally were in, because they are still their responsibility, basically. There's nothing saying that the local authority can cease that plan or no longer have responsibility, because it would be a disadvantage to the parents and the child, and the reason that they're going abroad is for deployment and not necessarily a choice, if that makes sense.